Skrosky, you don't oppose the Commonwealth's motion?
Judge, I do not oppose the Commonwealth's request at this time. I would ask the court that they set Mr. Luke held without bail, without prejudice. The reasons, therefore, are this. In a case certainly of obvious complexity, I received 29 pages of police reports within the past half hour. I am sure that there is going to be, with the magnitude of these allegations, more discovery coming forward. There are also other issues that I need to perhaps explore and investigate. I would ask that the court hold my client without bail and do it under Section 18 at Bridgewater State Hospital. The reason for the Bridgewater State Hospital request is I can tell this court, as an officer of the court, I make this request in good faith, and that this court, I think, has or can draw the inferences from the factual allegations contained in what's been recited by the government, that there certainly is a good faith basis to send my client to Bridgewater. Without going into great detail, I will tell the court also there is a history with my client, and I won't say any more than that, knowing that the court can also draw the reasonable inferences from that. To submit him to Plymouth, the Plymouth County House of Correction or another like facility will certainly also create, I believe, a security risk. So I'm going to ask you, with the assent of my client, who I've discussed this with, to send him to Bridgewater for a 30-day evaluation under Section 18. I'm not ready to raise any issues related to Section 15 at this time. It's way too early in these proceedings.
I think absent a petition, I'm not in a position to send him on the 18. It has to be done from a place of detention. Obviously, if there was an issue of Section 15, I would permit the psychologist to evaluate him and report to the court any findings that the court could base a commitment upon. So that you're not requesting that at this time, I take it?
I'm not. I will let the sheriff's office do what they want to do.
All right. Now, relative to the request as to setting the bail without prejudice, as of this moment, I see no reason not to address the bail and give you the opportunity to be heard on that. If I do set the bail with your assent, then it would be with prejudice unless, and it would be a firm bail unless the defendant advanced some theory that the facts and circumstances have changed and he would be entitled to re-argue the bail at that time. Obviously, he does also have a right of appeal to the Superior Court on the bail that is by this court.
But we'll avail ourselves of his appellate remedies if that becomes an issue, Judge.
And the defendant is ordered to be held without bail pending further hearing. Relative to the defendant's motion to preserve all handwritten notes, Mr. Middleton, Commonwealth has a position on that?
I don't, Judge. I would suggest it's premature. I understand the reasoning behind it, so I don't have a problem with at least notifying the officers not to destroy it.
Given that situation, the court will allow that motion. Relative to the request for funds, the court will allow that motion. As to the defendant's third request, again, the court does not have sufficient information to act on that request at this time.
If I might be heard inside,
Sure.
Should I approach?
No, it's an ex parte motion. It does involve state of mind issues. At this point, it would be premature to hear from both parties. Skrosky. The court is going to order the minutes reflect the defendant is to be treated as Q5. right, gentlemen, we need a pretrial conference date.
February 24th, please remember.
By agreement.
And guilty findings on both dockets, both 09526 and 09053, Larry, the defendant, will likely be held without bail in that matter on 530. Court not having heard any effects or issues as to that matter, that'll be without prejudice if the situation changes.
Okay, so your matters continue to February 24th at 9 o'clock for probable cause of pretrial. You're held without bail.
Thank you, Ron.
Thank you both.